I confess I have been set a bit of a tall order, coming to talk to you about the legal hurdles ahead, when half the world doesn't actually understand the legal hurdles which are behind us, is rather difficult. I'm also very conscious that the moment one opens one's mouth on this subject, one is described either as an obstructionist or worse, as an enemy of the people. And so as I've had various epithets of this kind banded in my direction in the past few weeks and months, one is always a little bit cautious about predicting anything. Perhaps it's just worth starting by looking back to what's happened in this momentous fortnight that we have just had. That's leaving Mr. Trump to one side just for the moment. The Supreme Court judgment was, in my view, a very logical one. And without wishing to say too much of "I told you so," I had actually been telling my colleagues that I thought that would be the outcome for a considerable period of time. The reason is really fairly simple. If you go back to the 15th century and look at the treatise written by Sir John Fortescue called De Laudibus Legum Angliae, in praise of the laws of England, which is a fascinating document because it praises and celebrates what he saw as English exceptionalism. For example, that we deplored torture and we had trial by jury, all things that he approved of. So thoroughly English, if I may say so. I keep on pointing this out to Jacob Rees-Mogg. He also said that the King of England cannot by his mere will change the law of the land. This can only be done with the consent of the whole realm, by which I don't think he meant a referendum, I think he meant Parliament. In fact, I'm sure he did. And really what he wrote in the 1460s for the young son of King Henry VI, who was next to be murdered outside Tewkesbury Abbey after the Battle of Tewkesbury a few years later, really does hold good today. What Parliament hath granted, Parliament must take away. And the problem that the government has had really since the summer is, I think, a little bit in grappling and coming to terms with some of those key underlying features that flow from the 1972 Act and are joining the European Union. It was Lord Justice Law in the Thoburn case who said the 72 Act is a constitutional document. And I think there can be absolutely no doubt that that is the case. One of the reasons why people like John get so understandably exercised about the impact of the 72 Act was because it turned certain traditional norms of how we do things in this country on its head. And in particular, it gave direct effect to European law as interpreted by the European Court of Justice in Luxembourg. And that was a fundamental change to our affairs. And linked to it is the fact that as a consequence, very substantial amounts of statute law, or equivalent to statute law, have been enacted in the intervening period, which affect our daily lives in a multiplicity of ways. And as all that derives from Parliament's decision to allow the 72 Act to be enacted, and which went in parallel with the international treaty signature done by Edward Heath when we signed up to the treaty, that is why Parliament has to have a role in undoing it. Now, the government had some perfectly reasonable arguments to put forward to the contrary. And I always took the view they were fully entitled to go and have this ventilated in the Supreme Court, and indeed 3 Supreme Court justices found in their favour, effectively saying, as everything depended on the treaty, then Parliament must have assumed that if the treaties were to lapse, which was a matter for the government, everything else would go with it. But the majority were not prepared to countenance such an extraordinary change to our legal framework without Parliament sanctioning it. So that is, John's quite right, what we are currently doing in Parliament at the moment. And he's also quite right that we are not triggering Article 50 and did not trigger Article 50 with the second reading vote, or indeed the third reading vote, or indeed when this bill gets royal assent on around the 2nd of March. It will then be for the government, will have the power given to it by Parliament by which it can initiate that trigger. And the trigger will be a very important moment legally. Although it's right to say that one of the curiosities of it is nobody really is 100% sure what the full legal effect of the Article 50 trigger is going to be. Now, that may be the deliberate fault of Sir John Kerr when he drafted this rather extraordinary article and suddenly decided that there had to be a way of getting out of the EU. It may be simply that it is massively opaque. But what is very unclear is whether the consequences of the trigger are reversible. Is it a revocable act? Is it an irrevocable act? And ultimately, a lot of politics comes into that. And the other thing which is linked to it is what more does Parliament going to have to do during this process, either to sanction further change or indeed to create new treaty. And the blunt truth is that most lawyers don't really know the answers to these questions. The government chose not to argue that Article 50 could be revoked, because if they had, they would have won the case, but it would also have meant that the case would probably end up in the ECJ. And I think the Prime Minister, for understandable reasons of presentation, did not wish to end up with the ECJ determining how Article 50 should be triggered. But it may well come about in the next 2 years that the revocability of Article 50 will be tested. There's a case in the Irish courts going through at the moment on revocability, which may eventually get to the European Court of Justice. And so I think it's perfectly possible that at some point we're going to consider that. The other issue, which I think is very interesting, but which I just float, is the extent to which, leaving aside what the government chooses to do, and I'll come back to this in a moment, actually at the end of the process, whether in fact Parliament still has to enact further primary legislation to finally take us out of the EU altogether. There are two views on that. One is that on the face of it, one interpretation of triggering Article 50 is the bullet that's fired which hits its target 2 years later. So if the government chose to do absolutely nothing between the date it triggers Article 50, 2 years later we drop off, as some people say, the edge of the cliff, or as some of my colleagues in Parliament like Jacob think, the moment when we spread our wings and soar into the skies. But, yes, Icarus does spring to mind, but we can come back to that later. But there is an argument that actually Article 50 in itself may not be sufficient to give the government the power for full withdrawal from the EU, even as a matter of law, and that actually there would have to be a further statute at the end of the process saying that we're coming out. Now, in practice, this may all be a little bit academic, because it does seem to me that as the government is seeking some continuing relationship with the EU and does not wish to jump off the cliff, the reality must be that this matter will come back to Parliament at some point. You will be aware that as the second reading debate has swilled around, we had the second reading. This Monday, Tuesday and Wednesday, we have the committee stage of the bill being a constitutional measure. It is taking place on the floor of the House. I can't remember, John may know now, how many amendments have been tabled, but the last time I looked it was well in excess of 150 and rising. I hope I may be forgiven to say to those whose enthusiasm on the opposition benches have contributed to this avalanche of legislative ingenuity, I think that the vast majority of these amendments are completely useless. They will not make any difference to the basic issue, and it is plain that it is not a good place to start imposing a framework on government in the Article 50 process. Obviously, some of the amendments say things like, and when you go off to negotiate, you must make sure that we try, insofar as is possible, to stay within the single market. Or you must ensure that insofar as is possible, we stay in the customs union. But as an ex-law officer who spent half my life telling my colleagues in government that aspirational statements in legislation are very bad news and should not be embarked on. So I regret to say to my opposition colleagues, including Keir Starmer, who may have been behind some of the ingenuity, that I don't think these amendments are very helpful either. I don't think we should be seeking to fetter the government's discretion, although, as you will be aware from some of the mood music and some of the coverage in the newspapers, and indeed occasionally my name's appeared alongside it, there has been a desire to see that the government, without being excessively constrained in its negotiation detail, does make a statement about what it is intending to try to achieve. And in fairness, the Prime Minister responded to that firstly with her speech, with the 12 points, and then because some of us pressed a little bit harder and said that the ordinary processes are usually that the government publishes a white paper, with a little bit of reluctance, and I'm not sure I completely understand why, we got a white paper on Thursday. Now actually, it's well worth reading, and I don't know whether any of you have been able to download a copy, but I would recommend going to read it. Because I must say, I find it's a very optimistic document, and I don't mean that pejoratively. We've got to be optimistic. There are going to be quite a few pitfalls. I'll come on again on that in a moment. But it sets out a direction of travel which I suspect 99.99% of Conservatives would be happy to endorse. And indeed, I have to say, I think if the Prime Minister could achieve it, then I think we're going to be putting up statues to her in every town or community over 3,000 inhabitants, because it would be an extraordinary package deal, leaving the United Kingdom free to conclude its commercial agreements with third parties, free of the European Court of Justice and the direct effect of European law, but nevertheless incredibly closely embedded with the EU in terms of a trading relationship as near as possible to a single market, and miraculously no customs union. Well, a customs union because there would be no customs checks. Although all this, and I see James gently shaking his head in the front row, all these are aspirational and worthy, but not necessarily deliverable. So we have a white paper. The other issue, which is still swilling around for the coming week, and not fully resolved, has been pressure by some Conservative MPs, and certainly the opposition, saying that there has to be an assurance that the government is going to come back to Parliament at the end of the negotiating process to get Parliament's approval for any deal that it has put together before it signs it. And it then goes to the European Council and the European Parliament for their approval. Now, again, I think there's a little bit here of academic how many angels are dancing on the head of a pin. Because I have to say to you, I cannot conceive of a circumstance, really, in which a government, having gone through an incredibly complicated negotiation, even if the royal prerogative allows it to sign a treaty which is going to be of immense importance to the United Kingdom, would not actually get Parliament's approval for signing it first. That's what we've always done with major treaties. It would be done on a motion of approval by both houses of Parliament. It might require primary legislation, but that's not necessarily certain. But the idea that it would happen without Parliament's approval, I find rather far-fetched, which does make me a bit puzzled why the government seems so reluctant to just make a statement of what I see as the rather obvious, which is that it will come back and seek Parliament's approval. My judgment is it needn't go in the bill. The presence there is to stimulate the debate, but I would rather hope that we will get a statement from David Davis at the dispatch box at some time over the next 3 or 4 days, simply saying, of course we will come back to Parliament and get Parliament's approval for any deal, so that it removes the suggestion that the government would somehow try to bypass Parliament at the end of the process and present it with a fait accompli. Lurking behind that is the question of, might Parliament say to the government, Government, you haven't done well enough in this negotiation. We don't approve this deal, but we don't want to jump off the end of the cliff, so please go back and negotiate with our European partners some more. I'm not actually sure whether our European partners would necessarily be very favourable to such a course of action. And I'm not actually sure in practice if that would necessarily happen, therefore. But I think it indicates some of the areas of potential friction which have been developing during the course of the passage of the bill. I'm quietly confident that with any luck, we should be able to resolve it. That then brings me to, I suppose, the second theme I wanted to talk about today, which is this thing called the Great Repeal Bill. As far as we can work out, just to give an idea of the scale, at the moment we are subject to around 40,000 legal acts which come from the EU, 15,000 court verdicts of the ECJ and our own domestic courts in interpreting EU law, and 62,000 international standards that now apply to us by virtue of EU membership. Now, that's an awful lot. And it covers a multiplicity of areas of activity, including environmental protection, health and safety, consumer protection, and in addition to that, there are a whole series of private legal rights, intellectual property, competition law, freedom of movement, obviously, is one of them, rights of establishment, anti-discrimination law, some human rights coming from the Charter of Fundamental Rights, which is, of course, a very controversial document, but there is a lot of it. What are we going to do with it? As the government recognises, if we go and jump off the cliff, even if it's to soar thereafter, in reality, a huge swathe of English commercial and private life, at the end of the process, would suddenly find the entire legal framework around it collapsing into total chaos. And that's the bottom line. So the government cannot allow that to happen. So the Great Repeal Bill is not a repeal bill at all. The Great Repeal Bill is the Great Entrenchment Bill. It's taking this vast swathe of European legislation, it's saying to Parliament, we are going to incorporate it into our law so that at midnight on the day that we leave, this law does not disappear, and we can then get on with dealing with it, inverted commas, at leisure at a future date. Now, that's all very well, but I think it raises a number of problems, and it's problems which at the moment I can't really tell you how the government's going to deal with it. One of the big songs sung by those who wish to restore our national sovereignty by taking back control from the EU is that parliamentary sovereignty has been undermined by virtue of the way in which EU law can be enacted straight into our legislation. But of course, the ultimate irony is that the Great Entrenchment Bill looks likely to be the biggest Henry VIII clause in recorded history, because without it, it's very difficult to see how the government is going to create a framework. It's a genuine problem for them for dealing with this mass of legislation thereafter. So I anticipate that this is going to be a controversial issue. What form does the Henry VIII clause take? And how can we get all this down to manageable proportions for the years that follow our departure from the EU? I suppose Parliament could go into permanent session 24 hours a day. It would remove the taint that we sometimes have of having too long vacations. But whichever way you do it, it isn't easily realisable. So there's going to be a debate about that. I think the next issue which arises with the Great Repeal Bill is that there are going to be some people during the course of its passage who are going to want, so to speak, to show immediate benefits of departure. So I think as the Great Entrenchment Bill goes through, there will be some people who will be saying, yeah, but this can go at midnight and 1 second on day one. I hear this song from quite a few of my colleagues, and things like the fishing regulations, and there's a sort of mood music that these things might be disposed of as a signal on day one of Britain's emancipation. That too, I think, is going to be quite difficult. It's possible that we may find such symbolic items. But of course, you take something like the fishing regulation, the common fisheries policy. This is about our access into European waters. It's about European access into our waters. So it's likely in some way to be bound up in the total package at the end of the process. And that then brings me to the third point, which is that in fact, as I'm sure many of you, if you're in business, will be conscious, what really interests business is not a great entrenchment bill, but the question is, what will the terms of trade be with our European partners at 5 minutes past midnight? And on that, I have to say we are engaged in the realms of pure speculation. It's quite clear if you look at the white paper that the government understands the importance which the single market and the customs union have for us in terms of the free flow of goods. And of course, that leaves to one side the passporting of services, which is in fact of immense importance to us, and without which it is likely that elements of the financial services that we offer, not all, but particularly insurance, would founder completely. So this is going to be the subject of this negotiation. Now, Monsieur Barnier is a very elegant man, and I'm sure he's also somebody who may have a macro policy as well as a micro policy. But I'm bound to say that I think he is most unlikely in the course of a 2-year negotiation on terms of exit to ever be able to stitch the long-term deal which we can have with the EU, which we might like to have as a relationship with the EU in 10 or 15 years' time. So I do find it difficult to see that we will not end up, if we end up with any deal at all, with transitional arrangements. But that, of course, is in part dependent if we can work out the terms of our exit. Now here, I may defer to others in this room who may understand this better than I do. There's talk of our having to pay £60 billion to the EU for the privilege of leaving, being, as I understand it, the amount that they calculate we ought to pay for pensions and other things which we have had, or repayments. I haven't been able to explore this fully. There is, of course, as far as I can see, James will correct me if I've got this wrong, actually nothing in the treaties to indicate that you have to pay a penny on departure. And so it's rather unclear to me at the moment whether the payment is the quid pro quo for the transitional arrangements thereafter, or whether in fact the payment is based on a legal interpretation of the treaties and what the UK's obligation is on departure. Certainly on this, Article 50 is entirely and completely silent. But it's at least possible that the EU Commission could argue that customary law, international law applies, and that there are resolutions of outstanding debts or obligations which have to be interpreted into the treaties, even though I don't think I have seen them explicitly in them, although somebody may correct me about that, but at the moment I haven't. But as you'll appreciate, this too looks to me to be a fairly fertile field of potential difficulty. And whatever else we do, unless we wish to be in a no relationship with anybody, we are going to have negotiation. I mean, just to give an idea, people say, oh, well, it doesn't matter because at the end of the day we can fall back on the WTO. Well, yes, I'm sure we can fall back on the WTO, but actually the WTO is going to have to be negotiated. That's a negotiation with 163 other countries, of which the key partner is the European Union, because we will have to find a common position with the European Union to underpin our negotiation with the other 163 in order to get into a WTO relationship. So that in itself is not a fallback position that you can simply go to sleep and wake up in the morning and say, hooray, we're in the WTO, we will trade on tariff terms. And of course, everything else is going to have to be negotiated through. Now that brings us straight into the realm of politics. I have no idea how that will work out in practice. I think David Davis and the Prime Minister are correct, and certainly my impression is correct. My impression is from my visits and to my French interlocutors particularly, that everybody knows that it is in the mutual interest of the EU and ourselves to have a deal. But of course, that is something which can be derailed by emotion, poor diplomacy, swaggering at our end, pressure from the electorate at the other. There's 101 different things that could happen to influence that negotiating process, quite apart from the pariah status that the Commission really has with us, as you probably know, who are usually seen as being the devil. But actually, I think the problem is much more likely to come from the political dynamics within our EU partners. We have some key challenges. The government's made quite clear that it wants to maintain the closest possible trading and free movement relationships with the Irish Republic because of deep historic connections and the potentially adverse impact that if their disappearance would have on the Northern Ireland settlement, which, although it does not in any way explicitly require common EU membership, certainly impliedly had the common EU membership absolutely as one of its fundamentals. Maintaining the common travel area raises difficulties if in fact we end up with a situation where we are outside, for example, the customs union, although it may be possible to sort that out. I'm also not quite sure what's going to happen to the issue of citizenship, because I assume that any person who chooses to get an Irish passport living in Northern Ireland will continue to be treated as an EU citizen, but presumably an EU citizen who just happens to be living outside the EU. But of course you will bear in mind that I suspect the Irish might gently argue that at the time they signed up they rather thought that they would enjoy the rights and protections of an EU citizen living inside the EU. So that's one of the issues that's going to have to be looked at. The government talks extensively and constantly as one of its key goals that we must no longer be subject to the jurisdiction of the European Court of Justice. Now, the European Court of Justice is an international tribunal set up by its member states to resolve disputes of interpretation over the treaties. Its power extends only over that which the members have decided to pool in the treaties. Its exceptional nature, and the thing which has made people upset in this country, and I have to say, understandably actually, I mean, it was a major pooling of sovereignty, was its power to operate by direct effect. Leaving the EU, the direct effect will undoubtedly go. But what I must say I find much more problematical is the impression which sometimes seems to be conveyed that we're somehow going thereafter to escape the ECJ altogether. I've pressed the government rather hard on this, and it's interesting that when they published the white paper for the first time, there is an appendix at the back which tries to explain how this problem might be addressed. Because any continuing treaty that we have with the European Union is going to require interpretation and arbitration of the disputes. There's nothing unusual about that. The UK signed up to over 14,000 international treaties since 1834, and about 800 of them have arbitral mechanisms for resolving disputes, which we accept we will be bound by if it is adverse to us. As the Attorney General, I was dealing with this all the time. What sort of arbitral tribunal are we going to have? Now, reading the document, the appendix suggests that we will ask our EU partners to set up discrete arbitral tribunals to deal specifically with their bilateral relations with the United Kingdom. Well, that's possible, but I must say it's quite ponderous. Something in me says that the ECJ may not totally disappear from our lives, and in any case, the reality, and you can see it with the EFTA Court, is that ultimately the decisions and jurisprudence of the ECJ in interpretation are likely to be the ones which will be applied by the arbitral tribunals which get set up thereafter to regulate our relationship, simply because that is going to be the principal font of law dealing with the relationship between the states on the matters which concern them. I mean, just to give you an example which concerns me particularly, because it's within my remit as chairman of the Intelligence and Security Committee. The Prime Minister's made absolutely clear that security cooperation remains a key goal of the UK government. Indeed, it's a key selling point in trying to achieve a negotiated settlement, although not one which rightly she wants to use as a weapon, because I think that would be seen very badly by our European partners. A lot of that security, she as Home Secretary was the principal promoter of our signing back into those 35 agreements, which placed us under the jurisdiction of the ECJ on security. The Schengen database, PRUM, Europol, they're all there, and we want to keep them. How are we going to have that relationship? Are we going to be an associate member, so that actually we just sign in and we share in it, but we have no say in it, how it's run, and we simply have to accept the diktat of the Commission of the terms of the way it operates, if there's any dispute? Do we want an arbitral tribunal to resolve it? Do we, heaven forfend, still want access to the European Court of Justice to have these issues resolved if there is a dispute, and therefore an opportunity, at least for English lawyers, to influence the jurisprudence? I don't know the answers to all that. And that brings me finally, because I think I've spoken enough, to what is not the legal bit, it's the political bit. I just wanted to say something about that. I'm absolutely convinced that if we want a solution, and a lasting one, then we are going to have to exercise common sense, pragmatism, eschew ideology, and lose some of the wackier rhetoric which seems at times to be flying around. Because without it, quite frankly, I don't see why our European partners won't simply fall into the same process. I was very struck. I went to the Franco-British colloque in Paris last weekend. And it was a rather remarkable meeting, partly because Monsieur Fillon, who you know is in a bit of trouble over monetary payments which make our own expenses look rather shallow by comparison. Having risen like a meteor, the moment had come when it looked as if he is plunging to earth. And indeed, I'm not sure he isn't in a subterranean state now, but he's well on the way down. And it was noticeable that there were two completely opposite views being expressed on the French side about the future. There was the French official view being put out by French politicians like Henri de Castres, who's the sort of vicar on earth to Monsieur Fillon, but also French officials from the socialist background, saying, well, Britain's departure is very unfortunate. We regret it. You will regret it. As for the EU, well, everything's pretty much all right. We're going to cooperate together very closely. Everything's going to be all right, and you just wait and see. We will sort it out, and in 5 years' time, you'll be regretting it even more. That was their view. Then I have to say there were the French industrialists who were saying, Europe is in terrible crisis. We haven't a clue what's going to happen next. We're very worried about the future. We think it's quite possible the euro may collapse. And as for the political future, whether it's France, Germany or Italy, there are massive uncertainties, and in fairness, with which we should all be worried. The one thing I don't think we should have is that dreadful German word Schadenfreude, which is taking pleasure in the problems of others. So all this negotiation, and I hope I've tried in brief terms to sketch in a bit of the legal complexities. Somebody will tell me afterwards I've left something out. So I apologise about that, but even I can't get my head round it all, and I seem to spend my time wrapping a wet towel around my head and sort of trying to make head or tail of it. But ultimately, all this is taking place against a moving target and landscape change, which seems to me to be unfolding on a daily basis. And that's going to be a real challenge, because whatever else we want, we need stability. Stability is political and economic stability is the mother of economic growth, prosperity and a good quality of life for the people of this country. And what with Mr. Trump's trumpetings, and what with Mr. Putin, who is a thoroughly dangerous man, we are actually at the moment in a greater state of uncertainty, I think, on the European continent than we have been since the 1930s. So all the more reason why we need, and I always make this point to some people who keep on asking me to jump up and down more in Parliament because of my views, but actually I take the view that supporting the Prime Minister in this matter is very important. The decision that was taken on the 23rd of June, unless there was a major change in public opinion, is what is going to have to be implemented. There's no point in just carping round the sidelines. But it is important to keep our eye on the goals and also to understand as we do it the problems that our partners in Europe are facing as a result of what we've done. If we can do that, then I hope very much we will come out with a satisfactory solution. What I will say is that the Prime Minister's pragmatism in this, which has been shown on a number of occasions, does strike me as being a very good sign that she understands these issues very well indeed. Thank you very much.